name yourself, 625. Ooh, good evening, everybody. While we were waiting to go live, we were just here discussing a few tidbits about estate planning. And so we are officially live. So we want to welcome you to another episode of Real Talk Family Life, building shatterproof families one brick at a time. And so we are praying for God's guidance because we have some scenarios here that only He can take control of. But in the absence of God coming down and actually giving us the answers, we have two financial specialists, well, one in the legal field, one in the finance field, and we have another attorney who's going to join us tonight to discuss this very topical scenario. So we want to encourage you, as always, to use your emojis, raise your hand, use the chat feature, ask your questions on YouTube. We will be checking that chat as well. And we just, again, want to pray for God's guidance and revelation so that there's unity on how we handle estate planning and build shatterproof families and shatterproof communities. My name is Dr. Sasha Sutherland. I'm your host tonight. We have with us Mr. Patrick Moore, a financial services certified professional, and Mr. Felix Pearson, an attorney at law. But rather than me introducing our panelists, I'm going to ask these esteemed gentlemen to introduce themselves tonight and give us perhaps an opening statement on estate planning. Mr. Moore, let's come with you first.
Oh, well, you said esteemed, so I was giving it to Felix. But, okay, receive the best for last. Okay, so hi, I'm Patrick Moore. As Sasha said in her initial introduction, I'm a financial services certified professional. In normal talk speak, I'm an insurance and financial advisor here in Barbados. My experience in the field spans over 34 years now. Starting in banking and finance, and now I've gone over more into the insurance and personal risk field over the last 8 years or so. I'm a father. I have a family who I am very passionate about, and I want to make sure that I do the best I can to provide and also to give protection to them. And by extension, I want to do that for my clients as well too. Estate planning is basically the process by which we accumulate, conserve, and then distribute our assets and our property over our lifetime and during our lifetime. So we're going to look forward to speaking to you more on that and giving you answers to your queries. So I hand over to my esteemed panelist, Mr. Felix, Dr. Felix Pearson. That's a little joke.
All this libelous statements. Good evening, everyone. I'm Felix Pearson, currently Executive Manager of Corporate Services at the Trinidad and Tobago Civil Aviation Authority. I'm an attorney at law of 14 years standing. And in that period of practice, I must say that the experience of dealing with probate and letters of administration matters related to the estate of deceased persons have provided very fertile ground for issues arising out of estate planning. And if I have to make an introductory statement before we get into the details this evening, I would simply say, where there's a will, there's a lawyer.
I think that was a really good one. That was a really good one. So my first question, very simple one. Well, before we do that, let me just recap. In the first session on estate planning, it was magnanimous. It was fantastic. It was an eye-opener. We learned, that it was accumulation, conservation, and distribution of assets acquired by an individual from Patrick. That's what estate planning is. We also learned that estate planning was not just for the rich or the wealthy and for old people, that as a young person, you start accumulating wealth. We also, well, as Felix said, where there's a will, there's a lawyer. So we declared that lawyers were needed for the formality in crafting your documentation and ensuring that your final wishes were executed. And in the event of a challenge or a challenge to the will, to avoid, the estate having to lose some of its resources because one of the family members would have brought a challenge to the will. We also learned that wills can be challenged if someone has a stake or has invested in the estate and feels like they weren't given their due when the will is read and wants to claim on that investment. And then finally, we learned in that last session that although you might be the best child, as I am, I hope mommy's listening, I am your best and favorite child, my parents still owe me nothing. So my claim to being the best child means nothing, because at the end of the day, the will, or, it's about that person having their final wishes. So first question is very simple. What do I ask you, Patrick, or what do I ask you, Felix, when I don't know what to ask about estate planning? In preparation for this session, we went to our participants, we asked for feedback, and they were like, well, we don't even know what you'd ask. What do I ask when I don't know what to ask about estate planning? Let's start with, where there's a will, there's a lawyer.
Sure, Dr. Sutherland. When we get into talking about estate planning, it's always good to start at the fundamentals, and that is by asking the question, what is estate planning? And I think we have answered that question somewhat. And once we have a sufficient appreciation of what is estate planning, then the next logical issue then is to ask ourselves, why is this important, or how is this relevant to me? And we would have spent some time trying to convince you on the last occasion that estate planning is important because it concerns your assets, it concerns whatever you would have accumulated, that you would have some jurisdiction over, that you may want to utilize to assist in creating your own legacy. It also works to protect the beneficiaries, the persons that you intend to really benefit from the fruits of your labor. And there's also the very important element of working to protect and provide for dependents. So those dependents could be senior folks who have become reliant based on their own limited access to resources, or it could even be minors, persons who themselves would have been not yet in a position to earn and support themselves, but they require that level of support from persons who are in a position to do so and who would have assumed a level of responsibility for them. So it's very important in addressing the issue of estate planning that we understand the importance and how relevant it is and the extent to which it could impact ourselves and persons that are close to us.
Over to you, Patrick.
Right. Right. The questions that the person should ask, actually, in my role, basically, I would ask the questions to try and lead to find out what are the person's most urgent concerns. So when I'm talking to somebody about estate plan, I will find out from them, okay, so basically what I have to find out from you, depending on what stage of the estate planning process they're on. If they're older, like myself, the important thing I would have to find out, I would have to ask them is, so whom would you like your assets to go to? And the purpose of me asking that question is to help them decide, okay, while I am still alive, while I can still make the decisions, I want to say or put into effect the actions that I want to take place when I'm no longer there, right? If I know that I want everything to go to my wife, then I have to make, then when they tell me that, then I will then be able to say, okay, if that is the case, we need to pull in someone like Felix or Marvelly to be able to structure your wishes in a legal way that cannot be, let me rephrase that, that cannot be successfully contested. Somebody may try to contest them, but when you have a good lawyer that puts these things in place in a watertight way, then the person is just basically wasting time, and you can rest assured that your wishes will be fulfilled in the correct way. So that is my job, is to basically lead the person into giving me the information that I need to be able to put to pen to paper and say, okay, well, this is what you want done. These are the things that you need to put in place. And these are the professionals you need to call in to be able to get your wishes done. So I will hand over to the other part of our esteemed panel, and the live wire, Miss Marvelly.
Before you hand over, let me just introduce Marvelly is the third of our esteemed panelists this evening. She's also an attorney by profession. And Marvelly, the question being posed is, what do I ask about estate planning when I have no clue what to ask? Oftentimes, we give people advice about estate planning and they're like, well, do you have any questions? And everybody's blank and muted. And it's simply because they don't know what they should be asking? If you were to open the discussion, what do you ask when you don't know what to ask?
Well, if the person doesn't know what to ask, I think it's then up to the professionals to ask them some leading questions to ascertain where they go. So if the person doesn't know what, first of all, you probably want to look at a list of assets and what you have, what is the relationship in the family like, where you intend to, who you intend to give what to, and are there children, are there dependents, so the professionals are trained, I'm sure Patrick and Felix will agree, to ask those kind of leading questions to elicit the information that is needed. And once you have the information, then you have a framework within which you can engage the person.
Fantastic. Patrick, I want to go back to something you said, well, the example you gave about if you want to leave the entire estate or your wealth accumulated to your wife, that brings to mind revocable versus irrevocable beneficiaries. And I just want to know if you can remind us about those two and the importance of making sure you know which one you are applying on your policies or your estate, and then increasing assets and reducing liabilities. To our legal team, can you tell us what is a will versus a trust? So Patrick, revocable versus irrevocable beneficiaries.
All right. Well, when you're bringing up the term revocable and irrevocable beneficiary, that is usually speaking to like life insurance policies. So when you designate a beneficiary, you're basically saying the proceeds of this policy that is going to be paid on my death, the person I want it to be paid to is what we call a beneficiary. So when you hear beneficiary, that is what it's speaking about. Now, when you say that something is when you put a revocable beneficiary, that means that you can come at any time while you're alive, obviously, because you can't do it after you're dead. While you're alive, you can come and you can change the beneficiary. So if you put your loving daughter as your beneficiary when she was 5 years old and she was also loving and sweet and cute and everything, and then when she gets to 25, she's a raging demon that at every opportunity she brutalizes you and so on, you can go on side where she can't hear you, call your advisor and say, come by here and let me change this beneficiary here, please. So you can revoke that you can revoke that initial designation and change it to someone who you wish to have the proceeds of your death benefit from your life insurance policy. No, the problem is if you designate it as an irrevocable beneficiary, that's when the problem starts, because you cannot change a beneficiary on a life insurance contract if it is an irrevocable beneficiary without the permission of the beneficiary. The beneficiary has to sign off that they are willing to give over their interests and so on, right? So in the event of the scenario I just gave to you, I'm not so certain that the once loving daughter will be willing to sign off that she no longer wants to be the beneficiary. So my job as a professional is that when I meet parents at that very vulnerable stage, when they, I do anything for my daughter. No, not my daughter, she won't do that. I have to find a way to very diplomatically tell them, well, you never know what might happen. So it may be best to put it revocable, because even in the event of the beneficiary predeceasing you, it is very difficult to get the beneficiary changed even though they're dead, if it's irrevocable. So the best thing to do is always to make your life insurance beneficiary revocable, so that in any eventuality, foreseen or unforeseen, you can always make the change if that is the best thing to do, if that is the most convenient thing to do, right? So that is the difference between revocable and irrevocable beneficiaries, right? Like I said, I know it from the point of view of life insurance contracts, but Marvelly or Felix can speak to if that is something that would apply to other legal contracts as well too.
And before we go to Marvelly and Felix, one question that's applicable to you, Patrick, is when would one actually want to do an irrevocable beneficiary?
To be honest, I cannot think up of a real life scenario where you will want to make it irrevocable. Because as I said, even in the event of, not that it might not be the scenario that I drew where the person has gone totally, I don't know what, but if the person predeceases you, they die before you, whereby then obviously you would need to change the beneficiary. Once it is irrevocable, it is going to be a very difficult process to get it changed. So for all intents and purposes, I cannot see where you would want to make it an irrevocable beneficiary and it being beneficial to you. Once again, I would give over to Marvelly and Felix because they might know of a scenario where it might be a good thing to do, but I can't really say I can think of anyone where it is.
Well, before I give over to Felix, the short answer, and Felix will take the other part of the discussion, the short in terms of when you will give over to make it irrevocable, there are people in our society, and there are men, for example, who may have, you may have a nice family set up now, but you didn't start out like that, and you may have a child, you know, who probably was on the other side, and you want to make sure that that person is provided for and is not a part of the estate per se. Right? Because generally, if you have a named beneficiary in the insurance policy, then that person does not form a part of the, that policy doesn't form a part of the estate. So if you want to make a provision for that person that is separate and apart from the other familial ties relationship, that's a good way to do it. It's irrevocable. This is my gift to you. It doesn't matter about your treatment towards me. I think I have an obligation to you outside of this other relationship here. So I'm settling with you over here.
Yeah, correct. I would add that the irrevocable is particularly applicable in circumstances where the arrangement was set up for the specific benefit of an individual. So for example, if let us say you took an insurance policy in my name and you are the one that is intended to benefit should anything happen to me, then there is nothing incongruent with you establishing yourself as the beneficiary irrevocably, because it is set up deliberately so that you will benefit from the arrangement that is in place. And irrevocable beneficiary arrangements are really ideal just for those types of situations. But if it is that you want to retain a discretion, it is better that you maintain the revocable arrangement that allows you the flexibility to adjust and make a decision that you may want it to change further down. That's different to the decision that you're making now.
Okay. Understood. So then what about wills versus trust? What exactly are the differences between the two?
Right. So Marvelly alluded to it a bit just now when she spoke about the private arrangements. The major difference between a will and a trust is that a will takes effect upon death. So it's a testamentary document, and a trust can take effect during your lifetime, what we call inter vivos. So that it allows you the flexibility to put arrangements in place. And you have different types of trusts. For example, a secret trust that we may have mentioned some time ago as well. So if you want to make provision for somebody outside of the will for private or other reasons, you can set that up via a secret trust. And that could take effect during your lifetime, or you can make provision for it to take effect upon death. But basically, it allows you flexibility to make decisions within your lifetime, effect them during your lifetime, have them implemented, and not having to wait until you die. The will takes care of that at the point of death.
Okay. So again, ladies and gentlemen who are participating, feel free to drop your questions, comments in the chat. For example, on YouTube, we have one comment, revocable equals full stop, noted. So people are taking notes already. We want to answer some additional questions regarding estate planning, of course, within the context of the jurisdictions in which our experts are operating. And so I want to start with 3 myth busters. I have a will, so I don't need to think about estate planning. True or false? I'm going to come to Felix. I have a will. You need to unmute. Sorry. Felix, you need to unmute. Yeah. No, you're still muted. Hold on. Okay, Marvelly, can you unmute and start off? Oh, okay.
Felix, you're unmuted now.
Okay. Yeah, so I'm saying that is false. If you have a will, you still need to think about estate planning, because remember we said estate planning involves accumulation, conservation, and distribution. And until you die, the potential for you to accumulate, conserve, and distribute remains, though diminished it might be. So that there is always an opportunity for you to continue to engage in estate planning during your lifetime. A point to note as well is that when we talk about a will, we refer to a will as your last will and testament, which means that your will, inherent in that statement, is that your will could change at any time. So that in drafting a will, at any point in time, it would account for all your investments, assets, and interests at that point in time. But that can change over time, and making the provisions to ensure that they transfer as smoothly as possible to people or entities that you wish to receive them at the appointed time may warrant you having to make changes in that arrangement, so that it really provides for you to review your will periodically, update periodically, and it really is not a static arrangement. It's something that is dynamic. It could change at any time from any perspective, so that having a will does not mean that that is the end of estate planning. It is something that you need to continue to update and maintain.
Thank you. Marvelie, estates mean taxes. That alone will dry up the small estate that I have. True or false?
Not in my jurisdiction. So I'm trying to understand it. Estate mean taxes. You mean the taxes you're going to pay out? Somebody's querying the taxes you're going to pay out in terms of the distribution?
None of the estate, yes.
No, not in my jurisdiction. I'm not sure what obtains in Felix's and whatever, but there are some exemptions that you get from certain transfer taxes and stuff. So it doesn't necessarily mean that it dries up your estate.
Okay. So if I'm leaving inheritances to my children, in them acquiring the inheritance, they do not pay taxes in your jurisdiction.
It is not like the US system where you have inheritance taxes that you follow all of the, the monies and all the big bequests and stuff in the will. That's not our regime. So okay. I'm not sure what it's not our regime.
Yeah, likewise in Trinidad, we don't have taxes associated with estates.
Okay, and myth number 3, I should not tell my loved ones about my intentions if I think it will change their disposition towards me. Hat trick.
I've recently experienced, and I think we were talking about that in our little preview before we came online. I have a client whose husband passed away, and not only while she's here dealing with the loss of her partner, so she's dealing with emotional loss, she then had to try and steady her head to try and search to find if he had insurance policies, then she came across the policies, if they were active or not, and so on and so forth. He could have saved her some of that stress if he had basically said, listen, dear, I plan to be with you till death do us part, meaning that both we die at the same time 50 years from now. But in the event that doesn't happen, this drawer here, or pull that drawer, the contracts aren't there, the card of my insurance advisor is there, you call him and he can take care of everything. So that would be one less thing that she has to worry about and so on. So we should really, if we have estate plans in place, whether it's wills, whether it is insurance policies, we should let our loved ones who are going to be impacted or benefit from that, let them know the details so that when you're not there, it relieves, at least that aspect of the stress. Now, that depends now on the family situation, because the question implies that you may have some relatives that iron the clock and iron your stuff and saying we taking very long to belong and that sort of stuff, and you may be afraid that if you tell Bobby Joe that Peggy Sue is who the money going to, that you might have less time than you should have. So it depends on your circumstance. But I would give way to Marvelie because it looks like she may have some useful input to give us.
No, I agree with the notion that your family should know that your business is taken care of. So I can entertain the fact that you can say, well, here's my insurance agent, here's a card for my lawyer that you can call, once I'm no longer here. I do not advocate, especially my older people, I do not advocate sharing the details of what your intention is, nor what you have in your documents. I let them rehearse, especially the old ones that come to me, they rehearse a phrase. You let them know, I've already taken care of you and I've already taken care of my business. And that is enough for them. This is a card for the lawyer. This is a card for the insurance agent, whatever. It really, really messes with family relationships. I've seen too many of it, and you really don't owe them anything. You know, the details, I mean, a will, estate and stuff, as Felix said, is an end stage disposition of your property. As long as you are not yet dead, you are free to do whatever you want to do with it. So you tell them, oh, that, you know, that bank account is yours, and they start watching your bank account. You want to go on a cruise, they think you're whittling away their money. No, it is yours until that time when you're not here. And if at the time you exit and they realize there's nothing in it, they will not one point you were thinking about them, period. That's it. Not telling them.
Okay. So we have some more questions that we want to discuss, some estate planning scenarios. Someone in the chat posted number 7 on our list. Can you please speak about the concept of common law, wife and husband in relation to beneficiaries, wills, etc.? How does the law treat with common law unions? Felix, you want to start?
Sure. In Trinidad and Tobago, we have what we call the cohabitant has legal status, and the cohabitant spouse is defined as someone who have been in a continuous bona fide domestic relationship for 5 years or more immediately preceding the death of the individual. This status has to be established in law upon the death of the individual. The cohabitant spouse has 28 days to apply to the court for that status to be applied formally by the court by way of an application and an order of the court recognizing that person as having cohabitant status. What that does is that it gives that person the right to access the person's estate and to share as a beneficiary in law. It depends on how complicated the domestic arrangement is, whether or not there is a legal spouse, whether there's a legally separated spouse, whether the cohabitant spouse is the only spouse. That will determine the share that is applied to that person. So the cohabitant in our law can benefit, but interestingly, there's a nuance there where even though that spouse can benefit, they cannot apply. They have to stand in line and allow other closer persons to the deceased to be able to have the right to apply, but they do have a right to benefit.
Interesting. That's interesting. In my jurisdiction, the cohabiting spouse has priority to apply. So there's not that prevent that spouse from applying. And if somebody goes before, we will challenge it and we'll caveat it and you'll take your place in the line. In that regard, I think our succession act then probably treats the cohabiting spouse a little better than you all do in Trinidad, Pearson, just saying.
Actually, it was acknowledged as a bit of a lacuna in our law.
Yeah.
It was questioned as to whether or not it was really intended to be so. But the way the act was proclaimed, that is what happened. And the interesting flip side of that, which I have not mentioned, is that a legally separated spouse has the right to apply ahead of the cohabitant spouse, which is really a bit of a contradiction. But that is what the law currently provides for.
Okay, so there's an example of the law making an ass of itself. It happens in all our jurisdictions. Every now and then you'll come across, you know, and so therefore the law then will be causing more confusion in the process than the parties themselves, you know, where that's straightforward. Interestingly, our position is basically similar in terms of the spouse, the recognition of the spouse. And it says to those who are on this platform, you can encourage young people that a good live with is not the same as a marriage. You're going to be treated differently at law in both of our jurisdictions. What I would also add to what Pearson says is the fact that even though the person may not qualify as a spouse under our Succession Act, the person can also qualify as a dependent in the common law union situation. So you may have a situation where the person has not necessarily met the 5-year living together threshold, but if the person can show that he's a dependent or she's a dependent on the deceased in terms of mainly being supported by him, then that person can also benefit on the estate of the deceased.
Okay. And we have from one YouTube viewer, what is the process if you have no children and you choose an individual, example, a godchild, as a beneficiary in the event that your spouse passes before you? How do we treat with that?
I suspect that that person is talking about in terms of an insurance policy. And if that is the case, if she has her spouse right now currently as the beneficiary on her life insurance policy, and he predeceases her, then she's free to name another beneficiary, and it doesn't even necessarily have to be a blood relation. That's the beauty of an insurance contract. You can do that. So that is not a problem. If she has a godchild that she would want to bequeath or designate as her beneficiary, she can do that. It's not a problem.
Okay, great. Again, please put your questions, comments in the chats and we will get to them. So I want to go back to another question. What if I'm dying? I'm no longer able to legally administer the estate, and my wife, who is my successor, is also no longer able, whether it be Alzheimer's, dementia, etc. Does our only child automatically get that responsibility? Or is there something legal that has to transact for the child to obtain? So I can no longer administer, perhaps I have Alzheimer's or I'm sick. My wife, who's my successor named, is also no longer able to. Does responsibility automatically go to our only child? Felix.
Okay. When we say no longer able to administer the estate of another person.
Of my own estate. So I, Sasha Sutherland, have my estate, but for some reason I am ill, whether that's brain dead, Alzheimer's, etc. My husband, who was expected to live longer than I am, was named as my successor or the beneficiary. That person is also unfortunately ill or unable to execute. Does the responsibility then of obtaining or executing or becoming executor, for example, fall with our only child?
Right. So you have a will, right? And you're saying you have established a will, your will.
Yes.
And your wife was your executor.
Yes.
To administer your estate upon your demise.
Yes.
And now you're concerned that she may not be able to, when you're asking whether your only child could automatically get the responsibility.
Yes.
Right. So there is what we call in law the chain of executorship, which requires basically the existence of wills. So you will have a will and you will name your wife as an executor. Your wife, if she has a will, she would name an executor as well. So in law, following the chain of executorship, if your wife is your executor and she's now unable to probate your will, then the responsibility passes to her executor. So that's how we follow the chain of executorship. And anytime that chain is broken, then you now go into the laws of intestacy and you have the law kicking in to determine who will have the priority to apply and administer the estate.
All right.
If it is that you have a will for the want of an executor, then you have the priority established in law where you go to the next of kin and whoever else and you go down the chain. And if there is nobody, then you get to the point of the beneficiary, any of the interested beneficiaries to make an application to apply to execute.
Just on a point of departure, that does not apply in Barbados. So we do not have the same provision in terms of chain of executorship. That was abolished in our jurisdiction. I read the question in two ways. I thought when I looked at it, the person is saying I am alive, but I am not able to administer my affairs as opposed to estate. I think so there's a difference between which are current and your estate at the end stage. So if the person is, I can no longer administer the estate and my wife is no longer able to, it suggests to me that they're both alive. So the issue then to me would be, if you're no longer able to administer, what caused that? which is what you alluded to, Dr. Sutherland. If the person is no longer able to by reason of illness, but the person still have the mental capacity, then the person can do a power of attorney, which will nominate somebody. It doesn't necessarily have to be your only child. It can be the niece that treats you better than your child, or somebody in the church that treats you better than your own. Yes, once the person is competent. If the party is saying, I'm no longer able because I'm losing my mental capacity or whatever, then the child or another relative cannot to be made a receiver of your estate and be able to administer that based on the dictates of the law.
Okay.
That's what will happen when the people are alive. In relation to the death stage and the chain of executorship, any beneficiary can apply to administer with the will annexed. So that's a process.
Okay, so we have another question in the chat. Upon my father's death, I found out I have a sister. She has claimed she has a will from my father, stating she also has a will from my father stating she has claims to certain assets. So let me read that again. Upon my father's death, I found out I have a sister, and she also has a will from my father stating she has claims also to certain assets. Can this happen, and how can this be resolved?
Story coming out at the funeral.
Right, it can happen. It can happen quite easily,
Yes.
and that is why the operative word is your last will and testament.
Last will.
And once we begin to speak about validity of the will, it has to be dated so that that point can be established. So it is what is the last valid will.
Yes.
Is what will be probated and accepted by the court. And that is the major determining factor there. But
exactly.
Just to make the point as well, in terms of establishing what may be the last valid will, it really speaks to the safekeeping of the will once it is executed. And in our jurisdiction, we recommend to clients that there is the probate registry. Once you have completed your will and it's duly executed, we recommend that you take it to the probate registry for safekeeping, and you will be issued with a receipt, and your executor would be able to access that receipt and go to the registry at the time to access that document. It makes the search and the determination of what is the last will and testament very easy and very academic, so that it doesn't really warrant a treasure hunt to find out what is the last will and testament if you follow the guideline really to lodge it with the registry. So it makes it very easy for tracing.
Somebody's asking what is the same. It's just saying I say to people, and men generally, not the internet, but men, you have to tidy up your business. And if it's a situation where you have somebody out there that you want to benefit, you may not want to do that in a will. You may want to do it in an inter vivos disposition. Some other creature at law that will give the person, talk to Patrick, that will give the person what you want to give them while you're alive. If you have a rider in there that you can set up any kind of agreement as to when it will take effect, but don't put them in the will to confuse the will. Because if you have the same date, and for example, what if it is this child, you have two children here, and the wife may be dissatisfied with her sharing the share of the will, and both of you are having a will dated the same date, it is a basis for challenging his competence. And if you and these are things that you challenge the competence. If he's making a will, two wills on the same date, something was wrong with his head, and the wife may want him to be declared to have died intestate, because she may stand to get more benefit on an intestacy. You see, so tidy up your business. So there's some people you can afford to give something while you're alive. But the thing that the fact that you put it in a will don't necessarily mean that is going to hold water, especially when you have these kind of loophole. I really like to go to town to the Supreme Court on that one with these guys. You're going to question his capacity, and it's a basis for overturning a will.
Understood. So, it brings us back to the question, and I think by now we probably know the answer. Can I reasonably do a successful will or trust without legal advice? What has been your experience with persons who've tried to do these things on their own, and it ends up before you? So Marvely, I'm going to come back to you. In your opinion.
Listen, pay the lawyer, pay the people. Listen, it is far cheaper to pay a lawyer up front to go through the process with you and put together a proper instrument than having to try to get an instrument probated that you did yourself. Yes, I'm now in the court of challenging one where the guy did 2 separate wills, and both of them, you know, a simple thing in terms of attestation, who witnessed the will. And both the husband and wife were saying, well, one was downstairs when he took the document and she signed it. The other was upstairs and came up and he signed it. So they were never together in each other's presence witnessing his signature. And on that basis, we were able to throw the second will. Yes, and reinstate the first will. So it's not only the fact that you know English language, it is the fact that you know what you want. It is the fact that certain processes must be adhered to, and pay the lawyer. They went to school to do that. It's going to cost you a lot less. And it's the truth. And I'm saying this not because I don't want money, because sometimes I say, make all of them, man, make your will, because we're going to get more fees down the line to challenge them in court. But we're saying to you on a platform like this, pay the lawyer the limited amount of money to do a proper document for you, and you're going to save your estate a lot of money against challenges to the will that is going to whittle away the money you want or whatever asset you want to leave for the beneficiaries in the final analysis. That is my experience, I think. So pay less upfront, and it saves you a lot more at the back end. That's my experience.
Yes, I would want to agree with Mavli with the simple statement that you need to consider the cost versus the benefit. In our jurisdiction, it can cost you 1,500 to 2,000 TT to make a will. If you have to go to court to deal with challenges with respect to estate, it will probably cost you 10 times that amount. Exactly. But more importantly than that, though, just for your appreciation, people need to understand as well that there are certain formalities.
Right.
And if they're absent, they could be very fatal to the process and to your intention. And it is important that people get an appreciation of that, because with the internet available, and so people feel that they can go onto the internet and pull down a template and it will allow them to put together a will. That is not necessarily the case. And there's some important element that I would just want to touch on quickly. Interpretation. Very often someone have an idea of what they want to do, but they may not know the options that are available, how best to treat with it. As Mavli was saying, there are some things that you can do in survival. So wait until you die. You have an option of doing it now. That would be better to dispose of it now, to handle it in a manner that would be less traumatic, less expensive, whatever it is, a deed of gift. Some people may want to issue a life interest in a property. They may feel that they have to give away the property without retaining that. So those interpretive issues are very important as well. The process. It is also important for people interested in to understand what is the process of developing it, the requirements, and the legal formalities. Again, we may take things for granted. Gifts, for example, any element of the will can fail for what we call for certainty. And that is very, very critical and integral to the preparation of a will. Any gift that is uncertain will fail. So who you intend to get it will not be able to get it because of lack of certainty. For example, if you have a car, in 2021, you may be driving a BMW and you want to leave it to your nephew, Keith. And you may say, okay, to my nephew, Keith, I leave my BMW car. But then you didn't die in 2021, you died in 2025, at which time you changed your car and you're now driving a Mercedes Benz. So if your will is saying your BMW to Keith, in 2025, there's no BMW, you have a Mercedes, that gift to Keith is going to fail, because you didn't, what you would have to say properly in the will is, I leave my car, because you understand that it is not static, it is dynamic in time and it can change. So whatever car you have, that is what is going to go. If we're talking about beneficiaries, you may have a neighbor called John, you may have a friend from work called John, who you're custom liming with and so on. You may decide, okay, I leave to my friend John. Which John? That is again, you can have failure there as well. Plus, you have other important elements of the residuary clause, the qualifications of the executor, the issue of the witnesses, the capacity of the witnesses to function in that capacity, as well as not being a beneficiary. And you have the responsibility with respect to the formalities around the settlement of the document itself. And those are very important considerations that people may not see at the top, but it could basically spell the failure of the instrument that you intended to be the legal instrument to give direction on your demise.
Thank you. Thank you very much. So on the whole idea of gifts, etc., Patrick, I want to come back to you in terms of giving gifts to children. Should we consider in estate planning, when you talk about the accumulation, conservation, and then distribution of wealth, should we consider giving our children a head start when we talk about estate planning? And this is specifically with relation to insurance. So for example, I want to enjoy my life when, I retire and I want to travel, but I also want to make sure my children have a good head start. So the life insurance policy that I want to give to them costs 600. Should I abrogate that policy for the pension plan? That's perhaps 300. Or, what advice do you give to people when they think I want to leave something for my children? Should I live my life that way? Should I live my life saying I want to give them a head start?
Okay. When I'm talking to a client and they're balancing the concerns of caring for my children and making sure that they have a good start to life, and also against the risk of my getting to the point where I am no longer working and I don't know if my children will have the resources to support me or even have the inclination to support me. So should I put something in place to try and safeguard my future in terms of having money that I can actually live off of? It's not necessarily that you have to, it's either or. Your advisor may be able to sit down and work out a plan for you where you have coverage in the short and medium term that if anything takes you away from your family while they're dependent upon you, a significant amount of money can be put in place, can be put into the household to carry your child to the point where you would have wanted to carry them if you were still alive. On the flip side, now, that same plan will allow you that if you have a long life and you've lived long enough that you can get your children up and running, get them out there and give them the resources where they can go out there and they can become self-sufficient and so on. That same plan, when you get to the retirement years, will have accumulated money in it to help you with your retirement. So you can actually, if you sit down and your advisor does a good job of asking you leading questions, understanding what your concerns are, he or she can be in a good place then to structure a plan for you that would address the different concerns you have going forward. If something happens to you tomorrow, $1 million will be there that should be sufficient, managed properly, to take your child to the point where they can go out and fight on their own. That same plan, when you get to 65, should have accumulated enough in it that it would be a good retirement nest egg for you, so that you can go on and you would not be a burden on your children and you'll be still financially self-sufficient. So I hope that answers the question.
It does, and I have a lead-in question from there. So I'm older and I realize that I do have some capacity to take care of myself, but not, let's say it's at 60%. And so there's a shortfall. Do we have the concept of reverse mortgages in the Caribbean, or is that just a US concept?
Well, I can speak to Barbados. There have been more and more people have been asking about it because, like most things, Barbadians are very in tune with what's going on in the US and they've heard about the term reverse mortgages, but I haven't seen it being done here yet. It is something, as a concept that is from the US. It's basically where, as an older person, you have a house that you've paid off your mortgage. It's full of equity, meaning that it has value, market value. There's no debt against it, but when you get older, you need cash. So what you can do, you can go back to your financial institution and say, hey, I want you to advance me money based on the equity in the building. And what they would do, they would loan you maybe 60, 70%, either as a lump sum or in monthly tranches against the value of the house. You don't have to pay them back. And what will happen is that when you pass, if you don't have any person that you were going to leave it to, the bank would repossess it and sell it to recoup their money. Or if you have people that are coming behind you that would want to inherit the home, they would inherit the home, but they would have to pay back the bank either one time or over a period of time. to basically take full ownership back of the house. But it allows you to live in your house, to have a source of income that you can still live off of. But like I said, in Barbados, we don't have that concept as yet. And well, it sounds really good and it will really be useful in Barbados because we have an aging population. I am not sure how the banks are very liquid, but I don't know if it would be an attractive thing for them because at the end of the day, they may end up with a lot of housing stock on their book that they may not be able to sell and recoup the money that they put out there. But I don't know. Felix, you can tell me if that's something that is relevant in Trinidad.
Yes, I don't know that it is a policy of the banks per se, but I do know of one or two instances where persons were able to, the normal mortgage route, to mortgage the property, get access to the funds, and at the point that the person would have died, the estate would have been entitled to the residue, which is basically the difference between the sale value and the mortgage amount, and that goes to the person's estate.
Okay. Marvely.
Yeah, I am still plodding on the question, the thing. I am not one of those who believe that you should leave a big set of money for children. I especially when they're grown. I think you give them. I think what you also have to consider as your quality of life, as Patrick says, your quality of life. I've seen two adults and they're old and they've never done anything, get up and go to work every day, and you educate your children. My thing is give them a head start in life, a good education and enough values for them to make their way in the world. Yes, situations where old people are beaten and are unfair because you want to die quick to access their monies. I don't ascribe to that. I believe at the end of the day, if you have acquired something, that as a body of believer, the kingdom also needs to be built up. So it doesn't necessarily mean you go to your ungrateful children alone. You leave something for the church, you leave something for some, charity that is doing good work. But this notion of them sitting on and waiting because they know you have a good life insurance policy. People have died in strange circumstances. You don't know if the family killed them or not to get the life insurance policy. I don't ascribe to that. I really don't. But that's personal.
But to speak to what you said, Marvely, they have persons, I don't know if it happens here very often, but I know definitely in the US, in Vermont, so on, people have life insurance policies that the beneficiaries are charities, the church, and that sort of stuff. So, right, so they might be saying, oh, wait, I've got wind that there's an insurance policy out there, and then time comes, they realize that the church is smiling very broadly and they're very vexed.
Exactly. So. And that again is one of the issues the person mentioned. It makes sense to have a lawyer drafted so you take that away from the cloud of suspicion, especially when you want to leave things to your church. That kind of thing. You need it to be properly drafted. Let them make the way in the world. Don't find an insurance policy sitting around. I think we need to raise children who have the belief that we are better to them alive and in good health than dead. And the inducement over there is too much.
That's an interesting.
Just one quick point. The advantage with an insurance policy is that one, it bypasses the probate process. It's a contract between the policy owner and the company, and you can't really contest an insurance contract when the person takes an insurance policy and say that person is beneficiary, that person is a beneficiary. I have not heard any cases where somebody can come and say, well, no, no. The insurance company says the beneficiary is John Brown, cut the check for John Brown, and it goes there. And that is like Marvely mentioned it briefly. If there is a family situation where there's a child that is not from the marriage, there's an outside child, as we call it, the best way to deal with that is not to try and write another will for that person. The best thing to do is go one side, do a little insurance contract for the person, and when the person dies, his family may not even know that there was a death benefit that went to somebody else. And that would be the cleanest and the least traumatic way to deal with that type of situation.
Okay, so in the chat, we have one scenario, and then we're going to bring it full circle to what Marvely says about, raising Christian children and again, building shatterproof families, right? So the scenario is, if I'm an outside child and my parent dies without making a will, does his or her spouse have full claim to the inheritance, or do I have grounds on which to make a claim for a share in the inheritance? I'm going to come to Felix.
Dr. Stella, just repeat the question.
Sure. If I am an outside child and my parent dies without making a will, does his spouse or her spouse have full claim to the inheritance, or do I have grounds on which to make a claim for a share in the inheritance as the outside child?
Right. So in our law, let's say outside child, she's the child of the person who died, the male, and she's the stepdaughter of the spouse. In our law, the spouse is entitled to 50% of the estate, and any surviving child is entitled, or children entitled to share the next 50%. So once that child can show paternity, it really does not affect the fact that she's not the child of the stepmother. But once paternity is established, that she is in fact the daughter of the deceased, she will be entitled to 50% share.
Okay. And so the next question, at what point does a Christian beneficiary say to himself or to herself, it's not worth the while to fight over an inheritance? And that's for any of the panelists to start. And I see Patrick looking to his right, so I'm inclined to call his name. At what point does a Christian beneficiary say to himself or herself, it's not worth it to fight over an inheritance? And I'm sure we could think of Bible stories that link to this scenario, Patrick.
Well, you know, Sasha, my go-to thing is I usually look to the word, and I remember distinctly the Apostle Paul, one of his epistles to one of the churches, saying that you should never be carrying a brother or sister in the church to the court. That is shameful to do so, right? Now, if that applies to your brother and sister in the church that you're not even related to, I wonder then how much more that would apply to my blood brother and my blood sister. I as her blood brother and she is my blood sister, and I want to cut her throat over an inheritance. I've seen it happen in my family already with my grandmother's estate. And I actually have a portion of my family that I have not seen or spoken to in about 30 years over the fact that somebody vexed that somebody get this house and they ain't getting it. And as a believer, I will have to think that I will have to value, I should be valuing the relationship with my family member more than money that I get in my hand today that I'm not going to remember where it went next year. But that is, but you know, a lot of persons will think that that's too airy-fairy, that's not real life and that sort of thing. But as a believer, you gotta realize that what we don't see is more real than what we see sometimes. So it's scriptural, and that's what we're supposed to be walking up. So that's how I look at it.
Right. A bit too scriptural for some of us, right? I see Marvelly and Felix, they're cracking up. Do y'all wanna weigh in on this one, or we move on?
I would just say, basically, you know, at what point does a person decide not to fight? I would put that question to put that question out of the reach of the person who's inclined to fight. I would say the person who is making the will, the testator, deal with it in the will. Yes. So put a clause inside there. At some point, you have to know your children. You have children, you have family, you know the wife, you know the husband, you know them, yes? And you know the ones who are going to be contentious and fight for what they don't think. You put something in there. Anybody who challenges it, get the lowest coin in the realm and see how quickly your estate is divided properly. Not, you just have to come to that ridiculous level, but I'm saying you can put mechanisms in that will that will prevent it from being challenged in that kind of way. So, you know, they're like that, take it out of their hands. So they don't have to decide whether they're going to take others to court or not. You tie it up and make it hurt them to do so.
Okay. Felix,
that issue may also arise post the death of the person. If you're asking at what point is it worth the benefit? Because if it is that the testator would have declared his will a particular benefit, and then there is contention or dispute after the death, then you also have to accept the question there as well. Is it really worth it, or do you just turn away from that situation? And for me, really, I think it's a matter of principle as well, and the extent to which you're prepared to stand and defend and take a principled position in terms of ensuring that the testator's wishes are adhered to.
Yeah, and we don't want to prolong this, but I think it's important because while Pearson was speaking, something has jumped into my mind. The fact that sometimes the testator or the testatrix, whoever, is not dealing fair or has not dealt fairly. Yes, so you have situations, for example, where, because remember, a will comes out of a context. Yes, and you may have a family context where one beneficiary, for example, relying on promises that were made to him or her by the testator, would have improved the family holding, would have done certain things instead of investing in him or herself. Yes, and then at the end of the day, so instead of buying a house, I repaired a house, I paid off for the land that you were paying for and that kind of thing, only to find that at the end of the day, you left it in a will to the one overseas who sent you a postcard every Christmas. And therefore, what out of land, and by then you may also have family, so it comes out of a situation. So it's not all the time you can say, it's not Christian to do so. James said, if you don't have a wise man to judge among you, then you have to go to law, Patrick. You have to go to law. Because sometimes even in death, we're kissing a dying pillow, we're not doing right where your family is concerned. And therefore I appeal to some of the, the older ones. I'm not sure, I don't know everybody here, but you know what? Do right. If you have somebody there, you have a child there, and you encourage them not to go and get their own thing, but stay here, take care of you, take care of your wife, take care of everybody, run the business, put their hard-earned money back into the family home. It is not fair for you to leave it to somebody else. I'm just saying.
Thank you. So two YouTube questions. If there's a will, but the names to get the land are spelled incorrectly, would it cause a problem? Felix, that one is to you. And Marvely. 3 siblings have inherited their father's home according to his final will. How can they share the house equally? One sibling wants to live in it with his family and the other 2 don't. So Felix.
Right, so I did mention before that an important element about the will is this principle of certainty. And anytime there is uncertainty, gift fails and it goes to the residuary clause that to be addressed. So if names are spelled incorrectly, that gift can easily fail. You can attempt to make an application before the court if there may be other evidence to suggest. So for example, if I say my brother Jimmy, and it's 2 M's instead of 1 M or whatever it is, and there's only one brother you have called Jimmy whatever, and so you can make an application with affidavit and so to the court and see whether they would entertain that as qualifying the gift. But it is very important when we talk about the formality to ensure that there is certainty, because if there is a Jimmy with 1 M and a Jimmy with 2 M's, that can make the difference in terms of who it goes to. Or if there are 2 Jimmys, then nobody might get it in that manner as intended.
Is that an example of where a gift fails and perhaps we apply the residue clause, or is it something different? Okay.
Yes, and if you have uncertainty surrounding the gift or uncertainty surrounding the beneficiary, intended beneficiary, any uncertainty there can cause the gift to fail.
Okay, so Marvely, over to you.
Let me just say, I think I said it probably in another forum all the time when I'm doing succession classes. There is nothing in law called family property. It must belong to somebody. Yes. So if the gift is left for both of you, for 3 of you in equal shares, if therefore and one person wants and 2 does not, the person wants to be in occupation must pay out the other 2. So therefore, the value of the house is going to be divided in 3. Yes, and if you want to keep it, you're going to find 2/3 the value and pay out the other 2. Yes, and in fact, even Barbados, that is one of the eyesores we have, where properties are left to the family house. And you have this thing about the family house, and everybody go and come as they please. Nobody repairs it. And therefore, we have a lot of derelict structures all over the place. And your hard-earned property goes to waste because nobody wants to move. And the person who wants to stay in don't want to pay out the other 2. You give them a reasonable time to do so. And if they do not, you go to court for an order for sale, or the executor goes to court for an order for sale. And you sell it and everybody gets some monies. You can start fresh, everybody. Mm-hmm. That is really a troubling thing in Barbados.
Thank you. Patrick, can someone claim private property they've been squatting on? And what would be the scenario if the owner wills that land to a surviving relative? Well, the second part of the question, I'll hand over to the attorneys. Patrick's eye is like out his head. But Patrick, come on, we know this scenario in Barbados. Can someone claim private property that they've been squatting on?
There have been situations where people have been squatting on property long enough that when the substantive owners, the people that actually have the land title to them, have not been able to move them, and they've actually basically kind of lost ownership to it. They happened with a large financial company that had a flat tranche of land that they wanted to develop, and they had a Rastafarian community that was living on it for a long period of time. And when they went to try and remove the people, they could not. They basically abrogated ownership. So I am not treading any further than that on the legal point, because Marvelly will come and tell me trying to take food out of her mouth, trying to do her job. So I give over to the persons that have the credentials to give legal opinions. I'm gone.
So Marvelly, the second part of that.
There's enough food to share, Patrick. Trust me, I've been at it for a while. There's enough food to share.
The second part of that question, it's private property. What if I willed that land, that property, to a surviving relative? Does my relative have cause to take the squatters to court?
Yes, you can. And I remember clearly the instance Patrick was referencing, and it didn't mean that the people did not have the company did not have a right. I think the company chose to its public image, as opposed to take some bulldozers up there and bulldoze them off the land. Because in that instance, I remember clearly the company was actually giving them another parcel of land and a few $1 million to move, because they refused. There is no squatters' rights, even though you're claiming it must be one that is ventilated through the court. So you can't just go on it and say it's Jalan and Ja give me and so I own it. You know, you have to go to the court and prove that. And in that case, they got permission. So squatters' rights, again, is a creature statute that has a very limited parameters. So if you got on it because somebody gave you permission, you have acknowledged somebody with a superior title to the land. And therefore, that person was a superior title, can leave it to anybody they wish. Yes, if it's something that you go on somebody's land and you have never acknowledged somebody, then the law says after 20 years, you can claim it having gone through a process of the court. Having not gone through a process and I leave it to somebody, you ain't got no right. And the company should have taken some bulldozers up there and pulled down the shanties and see how quickly they would have gone for the $2 million and the 5 acres elsewhere.
Thank you. So Felix, similar question, but this time they're occupying state lands. Can the state land that's occupied be counted in estate if ample time has passed?
Right. So in our law, for a squatter to gain title, good title to any land that they occupy, private property, they must have 16 years of exclusive, continuous, and uninterrupted occupation. And for state land, you must have 30 years of exclusive, continuous, and uninterrupted occupation. Once you qualify and you go through the process that Marvelly outlined in terms of going to acquire it by adverse possession, you now gain superior title, and it is now in your possession, and you can dispose of it as you see fit, because you are the one that's now holding the title to that land. If you have not qualified and have not gone to the court system to acquire that title, then you are not entitled to distribute, because you can only give, the principle in law is that you can only give what you own. What is not yours to give is what you do not own.
Okay, and so one final scenario. My brother dies from human error at a hospital. He has a 2-year-old that I, his mother, am now left to take care of. I take the hospital to court and I am awarded a sum of money. Who is the beneficiary of the award, and does the child automatically get part of the award? Felix, I'll come to you on this one.
So, sure. So in civil suits like that, a suit for negligence, the person who benefits is the claimant. So let's say you could play with two scenarios. So let's say the claimant himself was in a position to make the claim for negligence, and any award of damages will be awarded to him. Then it now forms part of his estate, is available for distribution. If the claimant initiated the claim and he died during the course of the claim, that claim in some jurisdictions can be advanced by his executor, his next of kin, whatever it is, can continue and process that claim. And if they succeed, the proceeds from that will go to his estate. In some jurisdictions, a case of that nature, the claim dies with the claimant. In the case of someone else, if it is that the person died of negligence and a brother or a spouse decided to sue the hospital and they raise the claim, now they become the claimant. And any proceeds from that case go to them for their benefit. So that does not now form part of the estate of the deceased. It is now their entitlement and they have the discretion of how they choose to dispose of it.
Okay. Okay. I think we've answered all the questions in the chats. I have one question, representing God, of course. What would you present as an estate planning checklist for beginners? We're talking to a Christian community. We want to be responsible with what we've accumulated, what we've conserved, and now we want to distribute. I'm going to ask all three panelists to give us their estate planning checklist for beginners, anybody who wants to accumulate and distribute wealth, and then we will take any final comments from the audience and wrap up. So Marvalie, Patrick, and then Felix. Estate planning checklist for beginners.
What you need in the estate planning checklist for beginners. If I'm planning my estate, it depends on where I'm at the point in time in life. I think Felix mentioned that, Patrick mentioned that. So that my checklist, do I have dependents?
Okay.
If dependents, I'm going to look what benefit is my church going to get? How am I going to advance kingdom? Debt payments, of course, because those are going to come out first anyway. And my parents, again, it depends on where you're in life. Yes, so you're going to make some provision for your parents if they're still around, and your grandchildren for sure. You know, give them a little head start. I prefer give them a head start than give my children a head start. I mean, I've given them enough, because at some point your children need to come out of your pocket. That's just my philosophy. You know, they need to come out of your pocket. So basically that's where I am at, you know, advancement of the kingdom principles. I have a charity. I'd want to see probably some scholarships going to that. So I need that out. Do I have dependent children? And if they are not and they're grown, am I going to make provision for my grandchildren?
Thank you. Patrick.
Yeah, if I'm making a checklist for a believer, as a believer, that's going to affect how I'm going to speak to them as well too. As Marvalie did say, where they are at their life, what point of their life cycle they're at is important. If I'm talking to someone who's a young adult, starting out, looking at the estate building part of their life, I believe my job as a more mature person is to look down the road, factor in what I know they're going to be facing, the challenges that they will have, that they're going to face in trying to acquire home, get a family, all that sort of stuff, and try to impart my experience to them, try to vision cast for them to get them to know what they have to think of. So I would ask them things like, do you see yourself having a family? If so, then let them know that it will be a good time to start trying to put things in place. No, with a view to having a family, instead of waiting until when they get the family, which could be well down the road where it will be a lot more expensive for them to set up those sort of things. So basically, I'm going to go down. Marvalie did a very good job in summarizing. You look at those persons that depended on you. Now, if they know starting out, their family, their parents would have exhausted a lot of resources to get to that point. Get a policy so that if you foolishly go out with the fellas drinking too much or wrap yourself on a pole, you've been an expense to your family up to that point. Don't be another expense to put you on the ground. At least get something that you would not be expense for them to give you a good burial. And if you really appreciate what your family did, make it big enough that it would not only bury you and pay off all your debts, but also give them a little something for their later years, which you should be looking to do if you're Christian-minded and we're still alive when they get to the later years anyway, right? Factor in and basically tell them the basic biblical tenets of trying to build your estate. Spend less than you make. that way you can start to put aside money towards building that estate, right? But to end that, you know what? You're young now, you're healthy now, hopefully. You may not always be that way. Make sure you make provisions for health expenses, probably disability, that sort of thing, right? So because those are the type of things, those medical expenses and a long period of disability can seriously erode your estate plan, your estate, right? For to end that, you know what? I'm young now, I will not always be young. So cast your mind towards retirement. Not necessarily that you're trying to save up based on the money to leave to your children, but put aside money so that you will not be a burden on your children when you get to your later years. So those are some of the things that I would talk to them about and try to cast a vision, because I remember I thought it was invincible when it was in my 20s. You have to try and give them examples and try to cast a vision so they'll recognize you will not always be here, right? So that's some of the things that I would talk to my people about.
Felix.
Yeah, I would say you must begin by taking an account of your assets, and that encompasses not just your financial assets, but you make a list of all items that are valuable to you. And these can include items of sentimental value, whatever it is you have available that you would want to treat with in a particular way. Then you get into your material assets, uses of like your house, your furniture, your vehicles, your equipment, your tools, jewelry. Then you get into your savings, your investments, your insurance, your pensions, your debt benefits. So you basically take account of what you will have available to you to form your estate. Then I think you need to acknowledge as well your debts, because you continue to live and you may have liabilities as you continue to do so. So your auto loans, mortgages, any other obligations you may have, you consider that you make adequate provision for that as well. Although that will be catered for. The creditors would have a first port of call on your estate by an application if you haven't provided for it. It's useful as well to consider your membership in organizations, your church, any other institutions you may be having a relationship with that you may want to give a benefit to. You consider that as well so that you make them entitled beneficiaries to whatever you may want to gift. It is also a good idea to let your beneficiaries know which charitable organizations or causes you are close to, so that in the event that they may wish to support or make some voluntary donation, having received their gift. Your beneficiaries, you always need to update your listing of beneficiaries. And this is especially important if you would have recently been married or divorced. You may want to revisit your beneficiary arrangements. If there are debts in the family, someone predeceases you who you would have wished to benefit. So you always have to keep an open eye in terms of updating what will be your current list of beneficiaries. You would have the opportunity as well to consider transferring on debt designations, so that things that you don't necessarily need to put through the probate, consider the joint accounts and so joint property that once the person dies, it is not subject necessarily to having to go through probate, but the person intended to benefit can immediately access what is intended for them. The executor, we have spoken about that, very important. We may take it for granted, person of good mental capacity, and most importantly, likely to have the longevity to be present when you're gone, to manage your affairs, and available and accessible. You wouldn't want to choose somebody who's living in England and at the time you can't find the person, or the person wishes to renounce and you have difficulty getting an executor to manage your affairs. Your witnesses, individuals, again, with the sound mental capacity and able to make decisions. And remember as well that your witnesses are not entitled to be beneficiaries. So those are people who, again, would have to be available at the appropriate time, because the process requires at least one of them to be available at the time that you make the application for probate. We have spoken about the importance of the formality of the preparation of the will, that you really attended to that in a serious way. So even though you have all your information before you, you properly engage the proper legal counsel to direct and support you in that decision. Of course, a periodic review of your will, because we said it is a dynamic item. It is not static. Things continue to change. Life is constantly changing. Your assets will change. Your liabilities will change. Your wishes and your own arrangements for your support will change as well. The securing of the will is another very important consideration. Once you execute that document, safekeeping is important, because an executed will that is not available or is destroyed is going to frustrate the will of the testator and is of no value. So once that instrument is prepared, you need to ensure that you are properly secured. Other lifetime considerations, I would say power of attorney. The power of attorney is important. That is a lifetime instrument that would allow someone to be involved in the administration of your affairs. That dies at death. So anything that you want done in your lifetime, the power of attorney can do. Once you die, then the will kicks in. Advanced healthcare directives, whatever healthcare arrangements you want in place, funeral arrangements, people now receive letters of instructions so that they can be sure that they have their wishes. And a recent vintage now, you have digital assets where testators as well are indicating how they want the social media accounts and social media assets and so to be dealt with. So all those are contemporary considerations that you should really pay attention to in considering your estate.
Thank you. So, you know, when I think of everything that you guys have contributed tonight, I think about our personal responsibility as Christians to ensure our house is in order before we close our eyes. And of course, no man knows the time, right? No man knows the hour. So I just want to leave everyone with something from 1 Timothy 5, verses 4 and verses 8. If a widow has children or grandchildren, these should learn first of all to put their religion into practice by caring for their own family and so repaying their parents and grandparents, for this is pleasing to God. If anyone does not provide for his relatives and especially for his immediate family, he has denied the faith and is worse than an unbeliever. Just something to think about as we think about building shatterproof families one brick at a time, and really making sure the body of Christ knows not just the scripture verses, you know, but we can apply it in our everyday lives and we can be examples to those around us, not just to our immediate family, but to our communities of practice as well. And so I'm going to ask the panelists to just give their final wrap up on estate planning too. We just want to thank everybody for being here tonight. I want to acknowledge Pastor Griffith, who is just here diligently every other Tuesday with us. I want to thank Pastor Henry for just, you know, providing this opportunity for us as believers to talk about things that affect us, but that we don't necessarily get to speak about on a Sunday morning, right? So for creating this space outside of church where we can share principles that can be shared by each other. And I just want to remind you all, August 31st, we're going to be addressing the role of parents, in the education system. So the role of the parents in the education system in the Caribbean. Share the topic with your friends. Tell everyone, come ready to listen and ready to learn. So panelists, Felix, Patrick, Marvelly, thank you so much again for taking time out to do estate planning too with us. What are your final takes on estate planning?
I just want everybody to know that no matter once you have started earning, no matter your age, you're always in some aspect of estate planning. So don't think it is, oh, I'm going to have to worry about estate planning when I decide who I want to get what I have left. No, from the time you're earning, you're either building, conserving, or getting ready to distribute your estate. So just remember that.
Right. I just want to follow up on something I wanted to do a little earlier that Patrick said in the terms of casting a vision for your family or your children. And I would add to that, get them to participate in that process from early. So I'm saying, and I'm being real now, yes, I do teach a lot of young people, and I'm saying to you, adults here, that our society has changed. While we know what the biblical mandate is, we can no longer look to our children as our insurance policy, that they're going to do right by us. So I'm saying you do the best you can to give them kingdom values, but they have some choices to make on their own. So I'm saying, yes, cast the vision, but get them to participate in the vision early. And if you get them to participate in the vision of acquiring, if it's God that gives you the power to get wealth and they're acquiring early, therefore mean from the time they're working, they're coming home, the paycheck can't go and do that, and, and the things that are, really are inconsequential. So the beginning of home ownership, for example, is the beginning of wealth creation for Black people. Let them know, invest in a piece of land. You're not paying rent here, buy something over here. I'll help you to put something over here. If you give them that kind of engagement early, there are going to be less of them waiting for you to die, and I'm sure they're going to contribute more to your quality of life when you're older, because you've already given them a start on their way in life. Yes, so do it early. Let them participate in the vision early. Help them to build and acquire early. Do not see them as their life insurance policy. They are different. Most of them can't wait to flee and go overseas, and you won't see them. Yes, and while they have a responsibility to take care of you, don't spend everything you have on them. Give them the mechanism to make their way in the world and live. You know, just live some. You know, we have invested much in them, and then you give so much, and by the time it's retirement, you have all kinds of diseases because you refuse to take care of yourself because you didn't live investing in them. And I don't think that's godly. I think you have to strike that balance where you live fully, you die empty.
Yeah, procrastination is the biggest enemy of estate planning because somehow we associate estate planning with what no one likes to talk about, death. But while death may not be immediate, it certainly is inevitable, and it is an event we will do well to plan for. Improper or inadequate planning could lead to too many undesirable consequences, which ought to be avoided. Disruption in family relationships, hard-earned assets becoming wasted or getting into the wrong hands, contentious litigations, large sums paid in legal fees. It's all about protecting and providing for your loved one. It's about ensuring your legacy is carried out. It's also about the balance that Marvely just spoke about as well, in that while you provide for others, you ensure that you cater for your interest while you continue to live. Very often when we ask what time it is later than we think. So you can never do it too early, but you can certainly do it too late. Yeah. If you haven't already done your estate plan, I encourage you to do it now.
May I just jump in? I think we have neglected one little area. I don't think we're going to have another one on this. So I think we should just mention it. I think, you know, at some point you need to have a conversation with your spouse, your significant other, because I'm seeing a lot of that where, you know, father and mother are not in agreement as to who should get what, and it causes problems. So look at the whole notion of mutual wills, that we're going to decide among ourselves. We have acquired the asset together. We're coming together as father and mother, and we're making the same instrument. So your estate is contained and continued. You know, I have one the other day where, you know, the guy wanted mutual wills, and I think I did capture mutual wills, but then the wife provoked him to change his mind. And he changed his mind because he thought he was sure he was going to die before her, and the bad-minded daughter was going to be her problem. And it didn't work out like that. You know, the wife is now dead. You know, it's just one of those things. So now they scraped him up, thrown him into a nursing home, and you know, the bad-minded one is running rampant through the property and savaging their investments. At the end of the day, you need to have that conversation with your spouse. You're creating something together, sit down together and see if you could tie it up together, do mutual wills, you know, that both of them saying the same thing. And whoever dies first, the later one cannot change the intention, the joint intention of the parties. That is also helpful.
Okay, so again, thank you, everyone. Pastor Henry, I'm going to hand it over to you.
Thank you, Dr. Sutherland. Thank you, panelists, Sister Marvely, Brother Patrick, and Brother Felix. Thank you so very much for a wonderful, wonderful program. You have taught me a lot tonight. And as a matter of fact, I think before I mention what you have taught me, let me say to the audience, these guys have a phone number. If you want it, just put a message in the chat and ask them to send you the phone number. They're professionals. I recommend them to you. But get the thing done. All right. So I am praying, Brother Patrick, that the reverse mortgage comes to the Caribbean quickly, because one of the things that I've noticed is that it's not easy for children to take care of their parents when they're old, because those children are often in the prime of their life taking care of their children, and they just can't manage the old people. So, you know, I want the reverse mortgage because I'm going to hire a maid, I'm going to hire a cook, I'm going to get a nurse, I'm going to get a doctor, and nobody putting me in any old people home. I'm staying in my house. Who want the house when I'm dead? Then they're going to take care of the expense that I rig up. Thank you, Sister Marvelly. Lord bless you all. Join us in 2 weeks on August 31st. It's Independence Day in Trinidad. Join us on that night. We're going to have a lot of fireworks on the program here as we talk about the role of the parent in the education system in the Caribbean. Lord bless you. Have a wonderful night. And panelists and hosts, thank you again for a wonderful and great program.
My pleasure.
Thank you, everybody. Good night to everyone on YouTube.
Good night.